Hi, my name is Rob Ward. I'm a barrister here at Quadrant Chambers, practising in shipping and general commercial litigation. The title of this QBiT talk is What is Rectification? So the headline answer to that is that it's a way of correcting a mistake in a written document. It's a process by which the court may change the terms which have been agreed by the parties in that document. And in limited circumstances, the parties' subjective intentions may trump what is revealed objectively by the document. So, in the law as it stands, there are two recognised situations in which rectification might be sought. One is where a mistake in the document is shared by the parties. That's a situation of common mistake. There's also a situation in which one party makes a mistake which is appreciated and known of by the other party to the contract, and that's a situation of unilateral mistake. The burden of proof in a claim for rectification is on the party seeking rectification. It has been said that a party needs convincing proof, but the standard of proof is still the ordinary civil balance of probabilities. As an aside, it's also possible to correct a mistake in a document by construction, so long as two conditions are established. The first is that there's a clear mistake on the face of the document, and the second is that it's clear from the document what the correction ought to be. The main difference between correction by construction and rectification is that correction by construction is limited to the rules of construction. So, for example, generally one cannot look at evidence of pre-contractual negotiations, and the error has to appear from the construction of the document itself, which means that in some cases judges have said that the contract would have to produce an absurd or irrational result. Whereas in rectification, the evidence which can be reviewed is not so limited, and there's no requirement for the error to be particularly egregious. Turning then to the types of mistake which can be rectified. Sometimes a document may omit words, sometimes it may add words which ought not to be there. Sometimes a document may fail to transcribe words which have previously been agreed. All of those types of mistakes might be regarded as slips, but rectification is not limited to slips. Rectification can also apply in a circumstance where the written document, objectively interpreted, fails to reflect the party's actual intention. So how does one judge the intention against which the written document should be assessed? I'm going to look at common mistake first. So in common mistake there are two further subdivisions. One situation of a common mistake is where there's been a fully concluded prior agreement. That could be an oral agreement or a written agreement, and then subsequently there is a later written document which tries to either formalise the position or reflect what has already been agreed. If that later agreement fails to carry into effect properly the previous agreement, then there may be a claim in rectification, unless it's found as a fact that the later agreement was intended to vary or supersede the prior agreement. In cases of a concluded prior agreement, the approach of the court is to assess on an objective basis the prior agreement. But rectification is not limited to cases in which there has been a concluded prior agreement. In cases where there has not been a concluded prior agreement, a person would have to show 4 conditions in order to obtain rectification. So, first of all, there has to be a continuing common intention. Secondly, that common intention must be outwardly expressed in a manner which crosses the line between the parties. Thirdly, the common intention has to continue to the execution of the written document. And fourthly, the written document must contain a mistake which fails to reflect the continuing common intention. Previously in the case law, there's been some confusion as to what the parties have to show about the continuing common intention. In the case of Chartbrook Limited and Persimmon Homes Limited, the House of Lords suggested in obiter dicta that the court would approach a common intention in the same way as it would approach the cases of concluded prior agreements, i.e. it would look at the common intention on an objective basis. However, subsequently in a Court of Appeal decision, FHSC Group Holdings Limited, the Court of Appeal held that, in fact, it's the subjective intention of the parties which is important. However, that subjective intention must be outwardly expressed, and so it's not sufficient to rectify the document if the parties have coinciding subjective intentions which are not communicated. Moving then to unilateral mistake, there are 4 conditions to establish if a person is seeking rectification in respect of a unilateral mistake. First of all, A must make a mistake about the written document. Secondly, the counterparty B must know that A has made that mistake. Thirdly, party B must fail to bring that mistake to A's attention. And then fourthly, it must be inequitable in all circumstances for party B to refuse the action of rectification. One issue which arises in respect of unilateral mistake is what degree of knowledge does B require of A's mistake? So the answer to that question is that B must have actual knowledge of A's mistake. However, in law, that includes situations in which B willfully shuts his eyes to the obvious, and also situations in which B recklessly fails to make the inquiries that an honest and reasonable person would make. Rectification is an equitable and discretionary remedy. It's only ordered where it serves a practical purpose, and in some circumstances, if there's been excessive delay, it may be refused. So in brief, that is the answer to the question, what is rectification?